Administrative Law, Part 3, that is Lecture 3, Doctrine of Separation of Powers and the Principle of Rule of Law. Dear student friends, you are aware that I am Dr. Rega Surya Rao, Principal, Retired, Aided Law College, Maharashtra. In the last two classes, that is Administrative Law, Part 1 and Part 2, I explained you in brief about the administrative law in general. There are about 14 chapters in administrative law, out of which I told you that there are about 9 chapters, that is 9 topics and 9 questions, which are very important from examination point of view. Not only from examination point of view, these topics are very interesting and they are of great practical importance and public importance. In the last two classes, Administrative Law Part 1 and Part 2, I explained in brief about all the chapters. In particular, these 9 chapters. These 9 chapters or 9 topics are 9 most important topics. Now, after the completion of these two lectures relating to administrative law in general, in brief, I wish to take up the 9 topics one by one. The first topic, preliminary concept, administrative law, meaning, nature, scope, and everything, I explained in lecture 1, and I wish to take up the remaining topics. Now, I wish to take up the doctrine of separation of powers and the doctrine of rule of law, which are very important from examination point of view. Before going to take up the subject, dear friends, let me pray God, pay homage to my reverend parents, late Rega Apparao and late Srimati Kantaratnam, my godfathers, in particular my student friends and viewers who are instrumental for what I am now. In this particular class, I wish to express my special thanks and heartfelt gratitude to my students friends for their consistent and unstinted cooperation and help in reaching my lectures to number of people, and today they are responsible for the subscription of 2000. Dear friends, I am very glad to know that today my it reached 2000 subscribers. It is absolutely because of my student friends and viewers. I once again sincerely request you to inform my lectures to your near and dear. Dear friends, I have been observing whoever is subscribing to my channel, immediately I won't be able to express my heartfelt thanks. In every lecture, I express my gratitude and heartfelt thanks to each and every subscriber, each and every viewer. Dear friends, uh, if you are gracious enough to uh, visualize my lectures to the notice of very many numbers in thousands, I can have more and more inspiration and enthusiasm and also zeal to do hard work. In this connection, I request you to offer your comments as to what topics I have to complete. Today, within this week, I will try my level best to complete all the remaining topics of administrative law, and then I left some topics, important topics from property law, some important topics from two topics from civil procedure code. My ambition is to cover all the subjects. Now let me take up this chapter, second most important topic, doctrine of separation of powers and rule of law. First one is the doctrine of separation of powers. Dear friends, the doctrine of separation of powers means in every state, that is country, in international law we use the word state. We use the word state. In state there are two bodies. One is a ruler and other is ruled. Ruler is the government, ruled is people. People are the ruled. Ruler government is ruler. See, government, the state rules the people through government. This government comprises of three authorities, namely executive, legislature, and judiciary. Executive, legislature, and judiciary. The state, with the help of these three authorities or three organs, namely executive, legislature, and judiciary, govern the people. Mon- uh, According to separation of power, these three authorities must discharge their respective duties without encroaching upon another. So, in this connection, I wish to let you know about this doctrine of separation of power. It's a state practice in India, UK, and US. Now, coming to the strictly speaking, the doctrine of separation of power was originally originated by Greek philosopher Aristotle. Aristotle. You know, dear friends, not only political science students, but also all students are expected to know the great Greek philosopher Aristotle, but he is known for describing man as social animal. That is the reason why Aristotle is very famous to all students, not only political science students, but also others. Then the doctrine of separation of power was originally originated by Greek philosopher Aristotle, and it was developed by British politician Locke. In in 18th century, French jurist Montesquieu. In 18th century, French jurist Montesquieu coined the principle of separation of power or doctrine of separation of power for the first time, and developed this concept in his book Spirit of Laws, published in 18th century, that is 1748. So the chief exponent of the doctrine of separation of powers is French jurist Montesquieu, who in his Esprit des Lois, which means Spirit of Laws, published in 1748. 48. So thereafter, according to Montesquieu, the doctrine of separation of powers means in a state or in a government, there are three organs, namely executive, legislature, and judiciary. With the help of these three authorities or organs, state governs the people. State discharges its functions, and state rules. So, according to this theory of separation of power, the executive must discharge executive functions. The judiciary must discharge judicial functions. The legislature must discharge legislative functions, that is lawmaking functions. One authority should not interfere or should not encroach upon the functions of other organ. So here executive in India, executive in the sense council of ministers headed by chief minister and governor. At state level, council of ministers headed by prime minister and president of India. At union level or central level, that is executive. A legislature means lawmaking body. So Lok Sabha, Rajya Sabha, that is lower Sabha and upper Sabha respectively, headed by President of India, is legislature, central legislature or union legislature. Union legislature. At state level, Vidhan Sabha, Vidhan Parishad, legislative assembly, legislative council, headed by governor is headed by governor is legislative assembly headed by speaker, legislative council headed by a chairman, and followed by governor is legislative body or law making body. Similarly, Lok Sabha headed by speaker, Rajya Sabha headed by chairman of the Rajya Sabha, and then followed by president of India is central legislature. So all laws are made by this lawmaking body, that is central legislature. And by delegated legislation, state legislatures also make laws. And judiciary. All judicial function are to be discharged by judiciary headed by the Supreme Court of India. In simple words, in every state there is a government. The government has three departments or three authorities or three wings, namely executive, legislature, and judiciary. According to Montesquieu, who coined this principle of separation of power, the executive must discharge executive functions only, the judiciary must discharge judicial functions only, and the legislature must discharge legislative functions only. One authority should not encroach upon other authority. In other words, it means executive should not enter into judicial function, judicially should not enter into executive functions, executive should not enter into lawmaking, executive should not enter into lawmaking powers. This is the position. So here, when in India there are so many legislations, some branches of there are legislations. Some legislations are main legislations or general legislations. Some legislations are special legislations. These legislations, some legislations passed by central legislature, some legislations passed by state legislatures under delegated legislation. Some small piecemeal legislations are passed by the subordinate bodies with the under delegated power from state legislatures. So this is the position. When a law is to be passed, a proposal to that effect is initiated from the executive. Then the executive will refer the matter to the law commission. Law commission will appoint a committee. Law commission will appoint a committee. Law commission will appoint a committee consisting of some members. This committee headed by chairman will go in detail with various aspects of the subject, and they will prepare a bill and send it to the executive. Executive will send this bill to Lok Sabha, that is lower house, for approval of 2/3 majority. After its approval, the bill will be sent to the bill proposing some legislation, new legislation will be sent to Rajya Sabha or upper house for approval of 2/3 majority. After getting approved from Lok Sabha and Rajya Sabha, the bill will go to the president for assent. After assent from president, the bill will go to the legislation will go to the assented legislation will go to executive. Thereafter, the executive will give gazette notification. Within that gazette notification, it will be contained that it will be notified in the gazette with effect from what date the legislation as a whole will come into force. Sometimes the legislation, all provisions in the legislation will come into force on same date, and different provisions will come into force on different dates. So these aspects I explained in detail in so many classes. When the legislation is notified, published in gazette, that is after gazette notification, this law will come into force. Such law will be applied by the courts. The courts will take into consideration the intention of the legislatures, the body legislative body, for with what purpose, with what objective the legislation is passed, keeping in mind the intention of the legislator, and keeping in mind the object of the legislation, interpret the particular legislation in a case. In a case, if they come across any conflict, the court may suggest some changes and recommend some amendment to that effect. So this is the procedure. So according to Montesquieu, a French jurist, the doctrine of separation of power envisages that in a government the three organs, namely executive, legislature, and judiciary, executive, legislature, and judiciary must discharge their duties, respective duties. One organ should not encroach upon another organ. That is, executive should not do legislative functions, legislature should not do a judicial function. Similarly, judiciary should not do executive functions or legislative functions. So this is what is called the doctrine of separation of power. Originally, the doctrine of separation of power is the extent of separation of power and rule of law are the most important concepts derived from constitutional law concepts. From in constitutional law, there are some constitutional concepts, namely sovereignty of the constitution, independent of judiciary, fundamental rights, rule of law, separation of powers, and certain constitutional principles are there. Basing on the constitutional principles, the administrative law is developed. So we, in this particular class, we take these two topics, namely separation of powers and rule of law. Separation of powers is a separate topic, rule of law is a separate topic. These two topics are come under constitutional concepts of constitution, administrative law, concepts of administrative law. Under this topic, these 2 points are to be discussed. As I already told earlier, the concept of separation of power was originally originated by Aristotle, and it is developed by British politician Locke, and for the first time it was coined by French jurist Montesquieu in his book Esprit des Lois, which means Spirit of Laws, published in 1748. So what is the object of this doctrine of separation of power? Just like concentration of economic power, you studied concentration of economic power in Indian economics. If wealth is centralized in few individuals, rich becomes richer and poor becomes poorer, it will result in inequalities, economic inequalities. Similarly, if the main functions, executive, legislature, and judiciary, are centralized in one authority, for example, executive authority, there is every chance for the executive to misuse its power and may take discriminatory decision, arbitrary, it may take arbitrary action. So if these three main functions, executive functions, legislative functions, and judicial functions, are vested in three different authorities, three different organ, there will be internal check between and among these three bodies. So that is the reason why the doctrine of separation of powers is envisaged. How it can be misused? In order to avoid misuse in centralization of power and arbitration of the arbitrary actions in centralization of power, this doctrine of separation of powers is coined or expounded by Montesquieu, French jurist, in 1748. For example, suppose these three functions are centralized in only one authority. For example, executive in sense ministry, union ministry, union ministry headed by prime minister and executive. Suppose all powers are judiciary and all powers are vested in it. There are some cases, we ours is there are some cases the union government which is in power wishes that in state also same party should come to power. There are some instances which the union government, the political party which is enjoying, which formed the government at union level, wishes to form government in state level despite despite no majority. In such situation, there will be a conflict between ruling party and other party, and whichever party, both parties claim majority. In such situations, the matter goes to judiciary. Yeah, then the judiciary will give appropriate direction. If the judiciary intervention is not there, if judiciary is not given such powers, the union government may act as a dictator, and we'll see that the same political party may be crowned in that particular province. So this type of disadvantages may take place. That is why Montesquieu initiated the doctrine of, coined the principle of separation of powers. Now, what is this state practice? Whether the doctrine of separation of powers, how it is applied in USA, how it is applied in UK, what is the position in India? So, state practice or position of the doctrine of separation of powers in USA, that is United States of America or America. What is the position in England, and what is the position in India? In USA, the doctrine of separation of powers is adopted and welcomed by US government. So, in according to Article 1 of the US Constitution, all legislative powers are vested in US Congress, that is central legislatures. According to Article 2 of the US Constitution, all executive powers are vested in president. Similarly, according to Article 3 of the US Constitution, judicial powers are vested in Supreme Court of America. So here Article 1, 2 and 3 confer legislative, executive and judicial powers on US Congress, President and Supreme Court respectively. So here, even though the US Constitution welcomed the principle of separation of power, it could not comply with the doctrine of separation of powers, because encroachment of one authority into other authority was quite inevitable. Here, that means even though US government welcomed the doctrine of separation of powers, and there are three authorities to look after these three functions: executive functions, legislative functions and judicial functions. But strict compliance to this rule is impossible, because if the president the president interferes in legislative function to give assent. Similarly, the Congress, that is legislature, interferes in appointment in judiciary for appointment and impeachment of judges. Here, strict compliance to, in US Constitution, even though Congress discharges legislative functions or law-making function, Supreme Court discharges judicial functions, President discharges executive functions. Sometimes President encroaches in legislature, Supreme Court interferes in executive functions and legislative functions. If any law passed by Congress is challenged, then Supreme Court will review that. That is called judicial review. Similarly, the president president being executive head, gives assent to any bills relating to passing of laws. So here, even though the doctrine of separation of powers was welcomed and adopted by US United States of America, the encroachment of one organ into affairs of other organ is inevitable. Here, uh, president enters into legislative functions, legislature enters into judiciary in respect of appointment and removal of judges, etc. This is the position of doctrine of separation of powers in United States of America, US or America. Next, what is the position of doctrine of separation of powers in UK, in England? In England, the doctrine of in England, the doctrine of separation of powers is not accepted. In England, there is no doctrine of separation of powers because here in US, in UK, in England, lawmaking bodies, that is House of Commons and House of Lords. House of Lords is upper body, House of Commons is lower body. House of Lords is just like Rajya Sabha in India, House of Commons is just like Lok Sabha in India. House of Lords and House of Commons are law-making body, legislative bodies, but still they decide cases. So when you study various subjects, we come across the decisions of the case, the decision given by House of Lords, the decision given by House of Commons. We come across how we come across the judgment given by Supreme Court or High Court, Calcutta High Court, like that. There are so many cases decided by House of Lords, House of Commons, which are lawmaking bodies. In UK, that is in England, the lawmaking bodies, the legislative bodies also discharging judicial functions. That is why uh, doctrine of separation of powers is not accepted. Then the cabinet, that is executive, British cabinet, that is Council of Ministers headed by Prime Minister, uh, through crown gives assent to bills. So executive is interfering in legislative functions. Similarly, the union cabinet in UK, in union cabinet in UK, Council of Ministers headed by Prime Minister can dissolve the House of Commons. So executive interferes into judicial functions. Executive interferes into legislative functions, and legislative bodies will also discharge judicial functions. So this is the position or practice of the doctrine of separation of powers in United Kingdom, that is England. So in England, the doctrine of separation of powers is not adopted, is not followed. Now coming to the question in India. In India, the doctrine of separation of powers, is partly adopted. In India, all executive functions are vested in executive, that is Council of Ministers headed by Prime Minister and President at central level, Council of Ministers headed by Chief Minister and Governor at state level. All executive functions are vested in executive. All legislative functions, that is lawmaking function under delegated authority from central legislature, are vested in legislative assembly, legislative council headed by respective speaker and chairman respectively, and governor. The legislative functions are vested in legislative assembly and legislative council. Legislative assembly headed by speaker, legislative council headed by chairman, and then governor for assent. And similarly, judicial functions are headed by Supreme Court of India. The Supreme Court of India and subordinate courts, the Supreme Court is vested with judicial functions. So The all judicial functions are vested in judiciary headed by Supreme Court of India. This is what. So in India, the doctrine of separation of powers is accepted, adopted, but practically speaking, it is partly accepted. In India, all judicial powers are vested in judiciary headed by Supreme Court. All legislative powers are vested in legislature comprising of Lok Sabha, Rajya Sabha, and Speaker, and then President of India. Executive functions are vested in Council of Minister headed by Prime Minister and President of India, the ultimate executive head. But the what this doctrine of separation of power coined by Montesquieu enunciate that one authority should not interfere, should not encroach upon the functions of other authority. That means executive should not do any judicial work or executive should not exercise any judicial power or legislative power. The legislature should not exercise any executive power or judicial power. Similarly, judiciary should not exercise any executive power or legislative power. This is the rule. But the what doctrine of separation of power, these three functions are vested in three authorities, but encroachment of one authority into another authority is inevitable. It cannot be practicable. Here, for example, if the law is passed, for example, the judges of High Court and Supreme Court are appointed by collegium. The judges of High Court and Supreme Court are appointed by the President of India on the recommendation of collegium consisting of the Chief Justice of India and four other senior most judges. That is. So here executive is interfering in appointment of judges. Similarly, when High Court judge or Supreme Court judge is to be removed from service, the process is impeachment. The members of the parliament by impeachment move can remove any High Court judge or Supreme Court judge. That is how legislature is involving in judiciary. Similarly, the state legislative bodies, legislative assembly or legislative council, and central level legislative Lok Sabha or Rajya Sabha, they have judicial power. Suppose if any for contempt of legislative council, contempt of legislative assembly, contempt of Lok Sabha, contempt of Rajya Sabha, if anybody commits any contempt, the house, whether it is Lok Sabha or Rajya Sabha or legislative assembly or legislative council, they can take a decision to arrest the person. In Ramoji Rao Inadu privilege moves case, Ramoji Rao long back in 1980s, when Chief Minister N.T. Ramarao was the Chief Minister, was Andhra Pradesh, when the Chief Editor Ramoji Rao made a publication in its leading news daily Inadu, Peddala Galata, when there was a conflict, there was a quarrel in a legislative council, it was published. Then the legislative council took decision for arrest of that chief editor. Meanwhile, the chief editor Ramoji Raoji fled for Delhi and obtained anticipatory bail. Then the conflict between judiciary and Supreme Court and Legislative Council, conflict between judiciary and legislature took place. These are the things. So here, even though in India these three main functions, executive functions are vested in executive, legislative functions are vested in legislature, judicial functions are vested in judiciary headed by Supreme Court, encroachment of one authority into another authority is inevitable, incompatible. For example, when the President of India is elected, the swearing in ceremony is to be conducted by the Chief Justice of India. When Chief Justice of India is appointed, his swearing in ceremony is conducted by the President of India. The swearing in ceremonies of MPs, ministers and all is to be conducted by the President of India. Like this. So here, even though in India the executive functions and executive function, legislative function, judiciary functions are vested in the respective bodies, encroachment of one authority into another authority is inevitable and incompatible. So that is the reason why uh, Friendman Friendman made a comment that the doctrine of separation of powers is not only a theoretical absurdity but also a practical impossibility. Friendman tells that the application of the successful implementation of doctrine of separation of power is very difficult from theory point of view, but from practical point of view it is highly impossible. So he basically condemns the application of doctrine of separation of power. He also expresses the practical impossibility for implementation of the theory of separation of powers. So because the doctrine of separation of powers coined by Montesquieu is not cannot be adopted 100%. It can be adopted partly. So these three functions, executive functions, legislative functions and judicial functions, can be vested in the respective organs without centralizing all the powers in one authority, but they can be these three sets of functions can be vested in three authorities, but encroachment of one authority into another authority is a must. It is inevitable. It is incompatible. It is essential. So that is why executive, legislature, and judiciary are three bodies which are not independently independent but interdependently independent. Since the conclusion is the three bodies, three authorities of the government, executive, legislature, and judiciary are in one way they are independently independent, in other way they are interdependently independent. So the doctrine of separation of power, the executive, legislature and judiciary are not independently independent but interdependently independent. See, next topic for discussion is rule of law. Next topic for discussion is rule of law. The rule of law is a founding stone. Is a founding stone. Is a founding stone for the development of administrative law. So here, the second topic for discussion is rule of law or the doctrine of rule of law. The doctrine of rule of law. So there are so many concepts of constitutional law from which administrative law is developed. Those constitutional concepts are sovereignty of constitution, independence of judiciary, separation of powers, rule of law are important concepts. From these concepts, administrative law has been developed. So here, what is the rule of law? What is rule of law? How it is applicable in administrative law is what we have to discuss. So here, the doctrine of rule of law was coined for the first time. The doctrine of rule of law was coined for the first time by Sir Edward Coke, Chief Justice of England, during the period of King James I. The concept rule of law was coined for the first time by Sir Edward Coke, the Chief Justice in England during the period of King James I. Thereafter, this concept rule of law was developed by British jurist Professor A.V. Dicey in his Law of Constitution published in 1885. So the rule of law is fundamental principle of constitutional law. it is the basis of constitution of any country, So this rule of law, earlier the king was the doctrine of pleasure was there. There was a doctrine, king can do no wrong. So king, the ruler, could do anything and everything. He can behead without any fault of anybody. But today, the king is also answerable and accountable. King cannot condemn anybody without application of proper law. Here, the king, Sir Edward Coke, while explaining the concept of this rule of law, says that the king is under God and law. That means God, whether God is there, we cannot see the God, but we can see the law. So the law is above the king, means the king must follow law while taking any decision. Sir Edward Coke enunciated that the king in a battle in war, with when he is in battle with his enemies, must follow the principles of law. So even king is not above law. That is what Sir Edward Coke enunciated. This concept of rule of law, coined by Sir Edward Coke, was developed by British constitutional jurist Professor A.V. Dicey. Professor A.V. Dicey and Sir Ivor Jennings are two jurists in England. They have formulated so many principles of law. So this doctrine of rule of law was developed by British jurist Professor A.V. Dicey in his book Law of Constitution, published in 1885. So the rule of law coined by Sir Edward Coke and developed by Professor A.V. Dicey has been acknowledged as the bedrock of the British legal system, and it was well accepted by US and United States of America and India. Professor A.V. Dicey, while supporting the significance and importance of rule of law, he criticizes the French judicial system, which French judicial system. That is, there is a separate judicial system in French constitution for public servants, government servants, one legal system, and civilians there is another legal system. So it is the rule of law is different for government servant, civil servant, and rule of law is different for public. That is what he criticizes. But rule of law must be one and all, even right from king to the ordinary man, right from porter to prime minister. Law must be treated alike. There should not be any discrimination in application of law, is what Professor Dicey enunciates. Professor Dicey, while explaining the concept of rule of law, gives three meanings, namely supremacy of law. First meaning of rule of law is supremacy of law. Second meaning of rule of law is equality before law. Third meaning of rule of law is predominance of legal spirit. So Professor A.V. Dicey gave three meanings. First one is supremacy of law. Second one is equality before law. Third meaning is predominance of legal spirit. According to first meaning, supremacy of law. According to Professor Dicey, according to rule of law, nobody, including the king or sovereign, cannot punish anybody without any breach of law. So those who breaches law, who violates law, can be punished. Without any breach of law, without any violation of law, nobody can be punished. That is what he tells. So supremacy of law is mean every country, every state will have the constitution of its own. The constitution of any country is called national law or domestic law. The constitution of any country is a document that contains rules and regulations as to functioning of three organs: executive, legislature, and judiciary. It is a document that contains the relationship between government and people. The constitution is supreme law of the land. supreme law of the land. In India, our Indian Article 31, Article 13, Clause 1 and Clause 2 of Indian Constitution speaks about law. Article 13, Clause 1 speaks about pre-constitutional legislation. Article 13, Clause 2 speaks about post-constitutional legislations. So, whether Indian Constitution was passed in the year 1950, so many legislations were passed in 1872. Indian Contract Act, Indian Evidence Act, transfer in 1872, Transfer of Property Act 1882 is there, Negotiable Instrument Act is there 1881. So more than 100 years, 130 years so old legislation is there. Indian Constitution is 1950, now 70-year-old, but there are more than 100 years. So any law, all laws before Indian Constitution 1950 must be as per Indian Constitution provision. If there is any inconsistency, any conflict between the provision of Indian Constitution and previous laws, that law is that law as a whole partly. If one section is inconsistent, one part is inconsistent, act is inconsistent with constitutional provision, that law is declared invalid or unconstitutional. Similarly, whatever laws are passed after constitution to even today, it must be according to constitutional provision, it must be according to central legislations. So this is about supremacy of law. Supremacy of law means anything is above according to law, but law is not according to anything. So the constitution, all laws passed subsequently or previous to Indian Constitution must be according to Indian Constitution, but Constitution is not according to pre-constitutional laws or post-constitutional laws. That is what is called supremacy of law. Second meaning of rule of law is equality before law and equal protection of laws. So there should not be any discrimination between sex, race, religion, rich or poor. All must be treated alike. So equal treatment. So same, if anybody is found guilty of any offense, the same treatment should be given. All must be protected alike. All must be treated alike in the eyes of law. So right from porter or police constable to Prime Minister of India must be brought before the court in the event of committing any this thing. Mrs. In the great personalities like Prime Ministers and Union Ministers were brought, are not free from the clutches of law. They were brought before the court. They were arrested also. The so-called great Mrs. Indira Gandhi, former late Prime Minister of India, was arrested and brought before the court for committing irregularities in election. So that is why equality before law and equal protection of laws, the relevant provisions are there in Article 14 of the Indian Constitution. Second, third one is predominance of legal spirit. So in India, the Constitution of India through its preamble envisages justice, liberty, equality and fraternity to all citizens. So the opening words of preamble of our Indian Constitution made it very clear: we, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secure, democratic republic and ensure all citizens justice, liberty, equality and fraternity. Justice, liberty, equality and fraternity are the four founding pillars of Indian Constitution, on which the huge edifice of Indian Constitution is built. So here, justice means social justice, economic justice, political justice. Social justice means minister's son and peon's son are allowed to sit in the classroom side by side. So similarly, rich man and poor man, high class man and low class man are allowed to sit in same train and public places, in hotels and everything, without any discrimination. That is social justice. Economic justice, equal pay for equal work. That is economic justice. Political justice, all citizens of the country, irrespective of sex, race, religion, and given an opportunity to exercise their franchise, vote, who have completed the age of 18 years, everybody is allowed to vote. And similarly, everybody subject to fulfillment of some conditions can contest. That is political justice. Justice, liberty. Justice, liberty. Like liberty, in this Article 21 of the Indian Constitution speaks about liberty. At the time of Constitution, Article 21 of the Indian Constitution guaranteed life and liberty. Subsequently, the scope of Article 21 has been expanded from time to time. So many items have been added: right to education, right to die, right to livelihood, free and free pollution environment, right to development, legal aid, whatnot. Very many number of items have been included in Article 21 of the existing. In 1978, the Supreme Court in Maneka Gandhi versus Union of India gave gave landmark decision, and the scope of Article 21 was enormously elaborated. And in this particular case, Supreme Court described three articles: Article 14, 19, and 21 of the Indian Constitution, and Part 3 of the Constitution, that is fundamental rights, described Article 14, 19, and 21 as golden triangle. These three topics I will explain in detail in constitutional topics, Article 14, 19, and 21. So in India, our constitution guarantees fundamental rights to the citizens and equal justice, social justice, and fundamental right. Article Part 3 of Indian Constitution, containing Article 12 to 35 of 25, lay down various provisions relating to fundamental rights. If the fundamental right, the Supreme Court of India is the chief custodian of these fundamental rights. If any individual, if any, whether by executive action prior to Maneka Gandhi case, and legislative action after Maneka Gandhi's case. After Maneka Gandhi's case, that is after 1978, after the judgment of Supreme Court in Maneka Gandhi's case, every individual is protected not only from executive action but also from legislative action. Protected fundamental right. If anybody's fundamental right is infringed or affected, he can approach Supreme Court under Article 32. So Supreme Court is the custodian of this. These are the various aspects, dear friend. The doctrine of rule of law is another important topic. In administrative law, dear friend, I have completed 3 lectures in administrative law part 1 or lecture 1, and administrative law part 2 or lecture 2. First 2 lectures I explained administrative law subject as a whole in brief. I told you 9 important topics or questions, and thereafter in first topic I have explained preliminary aspects in first 2 lectures. Next, second most important topic, rule of law and separation of powers, I have completed. Next, I will complete the remaining topics, principles of natural justice, order partum, and principle of bias in next class, in one class, and ombudsman I will take one class, and remaining topics I will take one class. And I once again express my heartfelt thanks and deep sense of gratitude to my student friends and viewers who are responsible for reaching the subscriptions to 2000. And I sincerely request you to communicate my lectures to your near and dear, so that I can have more inspiration and enthusiasm to work further. You please offer your comment, which subjects I have to take up first, which topics I have to explain in detail. Thank you very much. I once again express my heartfelt thanks for your kind cooperation in getting my in visualizing my videos to many more of yours. Thank you very much.